Okay, so this is the fifth video of the topic Companies Act, and we are using Saransh by ICAI, Institute of Chartered Accountants of India. I am Jaspreet. I am Company Secretary by profession, and I find this Saransh very attractive graphically. So what we are doing is that this is the disclaimer that we are only revising. We are just going through all the provisions. We are intending only to brush up our existing memory record and not to add something new. It is only with intent to brush up. So I am quickly going through everything. So now next topic which we are covering. Last we had covered registered office, changes in registered office, then subsidiary company cannot hold shares of the holding company except in special capacity or if it was already holding shares before becoming subsidiary company, and authentication of documents, that who can authenticate any document of the company, KMPs or any authorized person who is officer of the company, and outsider cannot authenticate company documents. Prospectus and allotment of securities, and private placement. So what is a prospectus? When a company wants to issue shares to public, then it issues a prospectus which contain multiple information about the company, basis of which, because this is a risky proposition, so shareholders make a decision based on the risk involved. So issue of securities. Issue of securities can be of two types: public companies and private companies. Now, private companies, let's cover this. Private companies can issue only three types of shares in three ways. It can either issue private placement, it can either issue rights issue, or it can issue bonus issue. Bonus is that you are offering further shares to existing shareholders of the company. Then rights issue, in bonus it is free of cost, and in rights issue you are issuing to existing shareholders and they have to pay for the shares, and they have right to renounce also. Means if they do not take, then these can be allotted to any other person. Private placement is that a few persons, there is a limit to how many persons other than existing shareholders the shares can be allotted. So in private placement, the offer is made to already identified other persons. Their names are provided, their list of names are provided in the board meeting, and to them this private placement is offered. Now, in case of public company can also issue bonus shares to existing shareholders without any cost, rights issue by taking money, and private placement to new shareholders, and by prospectus to public. It is public offer. So initial public offer and then follow a public offer. So prospectus contains number one, initial public offer, then FPO, further public offer, then offer for sale of securities. Offer for sale of securities, that existing shareholders are offering their shares to public, that they are also open to sell their securities to public. Now, prospectus. What is prospectus? This is subsection 70. So prospectus is a document described or issued as a prospectus, means it is clearly mentioned that this is a prospectus. Number two, it includes red herring prospectus. Red herring prospectus contain majority of information, but certain information like number of securities or price band at which these are issued, it is not included. So red herring prospectus is also included in prospectus. Then includes shelf prospectus. If for 1 year a standard shelf prospectus is created that remains in force, means for further shares can also be issued during that 1 year. So that is also included in the definition of prospectus. Then prospectus includes notice, circular, advertisement, or other documents inviting offers from the public. So when offers is invited from the public and all the correspondences for Inviting offers, notices, circulars, advertisement, those form part of prospectus. Then prospectus is for subscription of securities of the body corporate. So purpose, what is the purpose of this document which is titled as prospectus, includes red herring prospectus, can be a shelf prospectus, and also advertisement relating to inviting offers from public is also termed as prospectus. Now what is the purpose? For subscription of securities of this particular body corporate. This is the purpose. Next we move to contents of prospectus. Contents are given in section 26. Now contents of prospectus is dated, date of publication. So there should be a date in the prospectus, then expert report to be given only when expert is, these are certain terms which we'll cover. Then cover page of the prospectus, what all should be covered in the cover page of the prospectus. So let's cover all these one by one. So one is dated. Now when it is dated, then next follows is signed by. Who can sign a prospectus? A prospectus can be signed by a director or proposed director or attorney of director. So these are the persons who can sign the prospectus. Then prospectus contains financial info as specified by SEBI and central government. So it will contain financial information, last 3 years track record, and other things as specified by SEBI and central government. Then it will contain declaration regarding compliance of Companies Act, that this prospectus is drafted in compliance with Companies Act. Nothing in prospectus is contrary to Companies Act, SEBI Act, and SCRA. So nothing in prospectus is contrary. So this is an acceptance that we have duly complied and this prospectus do not contain anything contrary to Companies Act, SEBI Act, and SCRA. Okay. Next is expert report. So to be given only when expert is not engaged or interested in formation or promotion of the company. So expert should not be engaged in the formation or promotion of company. Then expert has not withdrawn the consent, means expert has given a consent and that consent is valid when the prospectus is issued. Experts gives the consent in writing. That consent is to be obtained in writing. Okay, cover page of prospectus. Now cover page of prospectus shall state that the copy has been delivered to ROC for filing. Means prospectus is to be filed with ROC first and copy is given to ROC for filing. Then number 2 cover page statement is required documents are attached to such copy delivered to ROC. That prospectus plus all the requirement documents are delivered to ROC. Process for variation in terms of contract of prospectus. If there are some variation in the terms of contract of prospectus, so as per section 27, there is a process that first SR is to be passed, special resolution is to be passed, then publish in newspaper including justification for such variation, why is there change in terms of a prospectus, so that should be published in newspaper. Give exit offer to dissenting shareholders. Okay, then those shareholders who dissent to this variation in terms of contract of prospectus, they will be given an offer to exit the company. They can sell their shares and go out of the company. Penalty for contravention of section 26. Section 26 related to contents of prospectus. Now if there is contravention or as to contents of the prospectus, then penalty is on company and penalty is on any officer knowingly a party to issue of prospectus, who is knowingly a party to the issue of prospectus. So on a company is a fine which ranges from 50,000 rupees to 3 lakhs rupees, and on person knowingly party to the issue of prospectus, fine ranges from 50,000 rupees to 3 lakhs. So in both cases fine amount is same. Company will also have to pay a fine and the person knowingly party to the prospectus will additionally will have to pay the fine. Shelf prospectus, red herring prospectus, and abridged prospectus. So shelf prospectus, what is a shelf prospectus? Shelf prospectus, in respect of which the securities or class of securities are issued for subscription in one or more issues over a certain period without the issue of further prospectus. So it is for a certain period, securities are issued over a period, and there is no requirement of issue of further prospectus. This is called shelf prospectus. Then red herring prospectus. What is red herring prospectus? Prospectus which does not include, what is not included, complete particulars of the quantum or price of the securities included therein. So either it is not containing particulars as to quantum of securities, how many securities are being issued, or the price at which these securities are being issued, then it is called red herring prospectus. Now, abridged prospectus. What is abridged prospectus? Memorandum containing such salient features of the prospectus. So, abridged prospectus is kind of a memorandum which contains salient features of a prospectus, as may be specified by SEBI by making regulations in this behalf. So, as may be specified by SEBI by making regulations in this behalf. Okay, so it is a memorandum containing such salient features of prospectus as may be specified by SEBI by making regulations in this behalf. So, abridged prospectus can be issued, and a link to complete prospectus can also be provided in the abridged prospectus. Next, we move to allotment of securities, section 39. Allotment of securities. Allotment of securities. So while allotting securities, we have to take care of minimum amount subscribed. So there is a requirement of minimum amount to be subscribed by shareholders. Application money has been paid and received by the company. So application money has been paid by the prospective shareholder and is received by the company in a separate escrow account. Application money shall not be less than 5% or such other percent amount as specified by SEBI. So SEBI will specify the minimum amount of application money which has to be received. Next is minimum amount not subscribed and application money not received. Now, what happens if minimum amount is not subscribed and application money is not received? Then we have to return. So the requirement is we have to return within 30 days from the date of issue of prospectus and such other period as may be specified by SEBI. Now, minimum amount not subscribed and application money not received, then within 30 days from the date of issue of prospectus or such period as may be specified by SEBI. In this period, minimum amount should be received. What will happen then? Amount received shall be returned. So if minimum amount is not received within 30 days, then the amount received shall be returned within 15 days from the closure of issue. Next is where company makes an allotment of securities. It shall file a return of allotment with ROC. So where company makes an allotment of securities, then it shall file a return of allotment with the registrar of companies, and once the return is filed, only then it can utilize money received for the respective purposes as provided in the prospectus. In case of default, if a default is committed, then company is liable and its officers are also liable for a penalty of rupees 1000 for each day during which such default continues. So 1000 per day is the penalty, or rupees 1 lakh, whichever is less. So if every day default continues and it do not reach amount of rupees 1 lakh, then the minimum penalty amount. If suppose every day default continues and after some longer period it is found that this was a default, then at that time maximum fine that can be imposed is rupees 1 lakh. Liability in case of misstatements in prospectus. So if there is a misstatements in prospectus, then there can be civil liability and there can be criminal liability also. Civil liability. Loss or damage is an essential condition. So for imposing a civil liability, loss or damage is an essential condition. However, for imposing a criminal liability, mens rea or guilty mind is an essential condition. Means there is a loss or damage, then it is civil. But there is intent to cause, means it was intentional. With the guilty mind, the conduct has happened, then it is a criminal liability. In civil liability, civil procedure code applicable or the new code coming in will become applicable. Offense against the counterparty. This is considered as offense against the counterparty only. And in criminal liability, criminal procedure code or the new code has become applicable, and offense is regarded as committed against the state. So this is committed against the state. This is also clear. Liability for misstatement. Liability for misstatement. If there is misstatement, then what is the liability? Again, there can be criminal liability for misstatement and civil liability for misstatement. In case of criminal liability, every person who authorized prospectus. So prospectus, every person who authorized the prospectus is liable, punishable under section 447. Okay. And defenses are available to this person to avoid criminal liability is immaterial. Either they considered that the misstatement is immaterial, it was not a material misstatement, or they had reasonable grounds to believe that this statement was correct, this statement was true, and there is no misstatement. They had reasonable grounds to believe that this statement was reasonable. So this way they can take the defense, avoid the punishment under criminal liability for mistake. Either it was immaterial or there is reasonable ground to believe that this is not a misstatement. Civil liability. Company. In case of civil liability, company is responsible, director is responsible, proposed director is responsible, promoter is responsible, expert, one who authorized is also responsible. Pay compensation to investors. Investors, they will compensate the investors. And then defenses against civil liability available to company, directors, proposed directors, promoter, expert who authorized are: number one, withdrew consent to be director. They withdrew their consent to be director of the company, or believed on consent under section 26(5). They believed, or issued without his knowledge. They confirmed that it was issued without his knowledge. And there was a public notice also with this respect, or it was issued but there was a public notice regarding this matter. So liability for misstatement. What we can get that the prospectus should be drafted well, there should not be any misstatement, otherwise there can be civil and criminal repercussions. Next is private placement. Now this is common for both public companies and private companies. So what is a private placement? Private placement. A private placement is a way of raising capital that involves the sale of securities to a relatively small number of select investors. Okay, a private placement is a way of raising capital that involves the sale of securities to a relatively small number of selected investors. In this case, investors are identified in advance. Private placement is different from a public issue in which securities are made available for sale on the open market to any type of investors. So public offer, public issue is for the general public, whereas private placement is to the selected investors only. Private placement, section 42. Section 42 provides any offer or invitation to subscribe or issue of securities. Now there is an offer to subscribe or issue of securities, an invitation to a select group of persons by the company other than by way of public offer. So it is to a select group of company and it is not in public offer. Through private placement come application. Through private placement offer come application. So a private placement offer come application is given to a selected group of persons who are already identified by the board of directors, and their offer is made to subscribe to the securities of the company. To whom can the private placement be made? Now, who are those selected group of persons to whom private placement offer can be made? Only to a select group of persons and identified by the board. Means there is a board meeting, the matter is placed that these are the list of persons to whom private placement offer is to be made, and then only to those identified persons offer is made. Maximum number of persons to whom offer can be made. Now, not more than 200 in aggregate in a financial year. So in a financial year we can make offer to 200 members and not more than that. Exclusions from the list of 200 members. Who are included? Who are excluded from this list of 200 members? Qualified institutional buyers. So qualified institutional buyers are not included in this list of 200 members, and employees of the company under the scheme of employee stock option. So if ESOPs are issued, then also employees are not counted in this 200 list, and qualified institutional buyers are not counted in this list of aggregate 200 persons to whom private placement offer can be made. And this 200 limit is for a financial year, means in next financial year then further issue can be made. Now in case of a private company there is limit to the number of members. However, suppose these are debentures, because this is about security, then debentures, in case of debentures this number can increase beyond 200 also, provided it is beyond one financial year. Also rules are to be checked. I think there is some other number also given. Application for private placement. Identified person may subscribe to the private placement issue shall apply in a private placement. Identified person may subscribe to the private placement issue shall apply in the private placement. What it means to say is that identified persons to whom offer of private placement is made, then they shall apply in the private placement. They do not have option to now go back. Application issued to such person along with subscription money paid either by check or demand draft or other banking channel and not by cash, means to whom application is made, then such person will apply along with subscription money which is not to be paid in cash. It either has to be paid by check, demand draft or any other banking channel like direct bank transfer, NEFT, but it cannot be received in cash. Utilization of money received in private placement. Utilization of money received in private placement. Company shall not utilize monies raised through private placement unless allotment is made and the return of allotment is filed with the registrar. So before utilization, obviously money will be utilized only for the purpose specified in the offer letter, but that money will not be utilized in any way. That will remain in the separate bank account until allotment is made and return of allotment is filed with the registrar. Return of allotment. Company shall file return of allotment within 15 days from the date of allotment. So in how many days return of allotment is to be filed? It has to be filed within 15 days. Company shall issue private placement offer cum application letter only after the relevant special resolution or board resolution has been filed in the registry. Registry means with the registrar. Company shall issue private placement offer cum application letter only after the relevant special resolution or board resolution. Means in certain cases board resolution is sufficient, but this has to be first filed with the registrar. So when you are offering shares, you have to first file offer letter with the registrar, terms and conditions, purpose, everything, and then you can make the actual private placement offer cum application. Private companies shall file with the registry copy of board resolution or special resolution with respect to approvals under section 179 subsection 3 and subsection C. Private companies will file, usually board resolution is sufficient in case of private company, unless special resolution becomes applicable if they are exceeding the provided limits. Now, any private placement issue not made in compliance of provision shall be deemed to be a public offer. Now see, if a private placement issue is made not in compliance with the provisions, then it will be deemed that it is a public offer and it will be treated as if the compliance, that a public offer is made without doing the due compliances. This is similar to what happens in case of deposits. If deposits are accepted in non-compliance of deposit rules and uh, sections, then it will be treated as if public offer is made without complying with the requirements. Okay, so next we have is allotment of securities under private placement. This topic is about to over. Allotment of securities under private placement. Now, when are the securities to be allotted in case of private placement? In case of public issue, we found that there was a timeline of 30 days. Otherwise, money is to be refunded within 15 days. But in case of private placement, allotment is to be made within 60 days from the date of receipt of application money. So, from the date of receipt of application money, that means when the money is received in bank account, from the date of receipt of application money means when the check is received by the company. If company does not allot within 60 days, then company shall repay the application money to the subscribers within 15 days from the expiry of 60 days. So when these 60 days has expired and a company has not allotted shares, then it will have to repay. If company does not repay within prescribed period, what happens? If company do not repay within 15 days after completing 60 days of non-allotment of shares, then company is liable to repay the money with interest at the rate of 12% per annum from the expiry of 60th day. After expiry of 60th day means that 15 grace period days were given, but interest at 12% per annum will start from the end of 60th day itself. These 15 days duration will also be added for the purpose of interest. Okay, so this completes our allotment of securities. All four types of completes only partial allotment, means we have covered only public issue and private placement. We are yet to cover bonus issue and rights issue. Okay, so next topic we will start share capital and debentures. Thank you for the day. Thank you.